When the Supreme Court reconvenes on Tuesday, the five-judge bench will have to dispense with the preliminary yet critical issue raised by activist Okia Omtata in the petition filed by Deputy Chief Justice Kalpana Rawal, contesting the Court of Appeal's verdict on the retirement of judges who have hit the age of 70 years. Omtata has argued that all the five judges are conflicted and hence would not fairly arbitrate the row between Rawal and her employer, the Judicial Service Commission JSC. Chief Justice Dr. Willy Mutunga chairs the Judicial Service Commission that his colleague on the bench, Dr. Smoky Nwanjala, is also a member of. The other three judges, Njoki Ndungu, Professor Jackton Ojwang and Mohammed Ibrahim, were last month reprimanded by JSC for staging a go-slow in solidarity with Rawal and Justice Philip Tunoi, who were directed by the JSC to proceed on retirement after attaining the age of 70 and 72 years respectively. One of the scenarios likely to play out on Tuesday is the five judges either unanimously or by a majority vote recuse themselves due to the apparent conflict of interest.
That's one scenario, and the case will end there and it will not go to the merits of the appeal.
The matter will rest as it is right now, and we'll have to go back and live with what the Court of Appeal decided.
That scenario will effectively end the Rawal Tunoi push to remain on the bench until they attain the age of 74, as they have argued.
In such a scenario, the senior most judge then becomes the administrative head of the judiciary, and in this instance is Justice Ibrahim Mohammed.
The scenario favored by some government figures keen on influencing the Mutunga succession contest is for the Supreme Court to rule it would proceed with the Rawal petition, notwithstanding the conflict of interest issues raised. With Mutunga's exit on Wednesday, the Rawal case would have to be adjourned, pending the appointment of the next Chief Justice.
In case they don't lift the order, then technically then Justice Rawal then becomes the administrative head of the judiciary. However, we must take into account that we don't have a scenario where a position like acting Chief Justice, or acting chairperson of the Judicial Service Commission. We don't have that.
Some legal practitioners have cited the doctrine of necessity, where less than the set quorum of five judges can sit to hear the Rawal Tunoi appeal, even after Mutunga's departure from the bench on Wednesday. However, Mkangi, one of the drafters of the 2010 Constitution, views such a proposal as grossly illegal since there was no deadline to hear and determine the matter, or its delay would precipitate a constitutional crisis.
We have to look at where we are applying the doctrine and the circumstances that are applicable to it. And on normal circumstances, the matter would be adjourned until further action is taken. So also in this, I think there are those considerations that have to be taken, and you have to remember that we are not saying that this is the end of the Supreme Court.
At play is the Mutunga succession contest and the scramble for the control of the Supreme Court. Among those touted as frontrunners for the Chief Justice's slot is High Court Judge Msaga Mbogoli, his colleague Isaac Lenaola, and Appellate Court Judges Paul Kihara Kariuki and Al-Nashir Visram. Attorney General Professor Githu Muigai is also interested in the seat. Francis Gashure, Sunday Live.